Okay, I believe you can see my screen, eh?
Yeah, saying it.
All right. No, we have a webinar tomorrow and the following weekend. Tomorrow, I'm talking about the advanced operators. In case if any one of you would like to participate, I can send you a link. It's just going to be 2 hours. It's tomorrow starts 11 Eastern Standard Time. And then the following weekend, also we have complex search queries, and the other thing is a workshop, which may be interesting. So that's something that if you want to provision for it, I can send you the link and you can join in. Uh, okay, that means we don't. I'm just trying to see if I can get to. Would be good. Just hang in there. I'm opening up the book. So we are doing the internet law. I'm going to talk about the privacy, the defamation, and spamming. These three topics we'll start with. Oh, just give me a moment. Mm, Just give me a moment here. Sorry about that. Uh, I just made a mistake. I called someone I was not supposed to, and it's just by accident, and they're returning my call. So I thought I'd let them know I made a mistake. My apology for this. Okay, so in this slide, I'm going to talk about privacy. The privacy is something that we all know of, especially in North America. We understand the privacy much better than most of the people, with the exception of few countries in the European side. So we have laws. which gives us rights as a consumer. It gives us opportunity to also be able to safeguard some of our information. There is these four different ones that we'll talk about. There is public information, which means it is in the public domain and it is shared. Some of it is coming from the government side, whereas others you have a control over, and you are given the option to either have it available publicly or you can make it private. So, not much to talk about on the public information, but there is privileged information. When we talk about privileged, we are actually referring to those type of records and information that otherwise, unless you have a court order, or there are special circumstances, or insurance companies, for example, they would want certain type of information, including your medical records that are not public information, but they are considered privileged info. Your background checks, at times it's different kinds of background checks, and some of them including your credit report, which you consent to, or where certain information you give away just because you um, are supposed to be taking some sort of advantage of any privileges that otherwise would be uh, kept as private info, but they are revealed on your assent, or your giving the assent for it. So those are privileged info. Then we've got private info, for which there are laws. We are not generally talking about the law itself, but basically just differentiating between these four different types of privacies. So the private info is for you to control, and it is privileged info as well. Unless you consent to it, it's not going to be revealed. Online privacy is something that is declared or considered as having a value for anyone um, that may decide or may not decide to um, reveal um, as as a privilege, or as something that unless you consent to, you may not be able to use somebody's platform, which is a virtual platform like social media and other information that you're given the option to either make it available for others to share, and at the same time you're able to use that website as well in exchange for giving out that information. Simpler examples are when you register for a website to view their pages, you would have to consent to it. And in the online privacy, there are two different types of agreements, generally speaking. One is called, uh, I think, there is a click wrap agreement. Hold on, let me get to it on the book. Mm, there is click wrap. Is it that? I think it's in somewhere here. I'm sorry, I'm just using my focus on forgetting where I saw that. There is two types of privacies which are separately indicated in the website. It's an agreement somewhere here. Here it is. There is browse wrap agreement and a click wrap agreement. Generally, you see these in the e-commerce website. Um, there are these terms of use which we can assume to have the same value as click wrap agreements or browse wrap agreements. It could come in two different formats. If it is a browse wrap agreement, you see it at the where the footer is. You see it says terms and conditions of use. And then in that, you also see an element of privacy, which gives you an idea of what type of information the website may be able to use or what information it will be protecting. So browse rep agreements are the ones that are basically assumed to be enforced as long as you're using those websites or reading through any of the content on those websites. That's implied, and it's called browse rep agreement. Then there is a click rep, which means that you have to, consent to certain terms and conditions for which you need to click or check on a small box that says you've accepted that agreement. Generally, these are the agreements that are very long, and you not being the attorneys or having a legal training, you may not be able to figure it out exactly in the sense of how it presents itself. So this is what we call, reading between the lines, or these are what call fine, we call them fine print agreements. So those are click wraps. So the difference between click wrap and browse wrap you can tell right now, eh? But when you are exchanging emails, there is a disclaimer or there is a statement that you put in at the very bottom of your emails, which remains constant whenever you are exchanging emails. That agreement, legally speaking, it's just preventive of a certain type of um, you can say a safeguard, but it is not enforceable in the court of law. So you know that that even if you put those statement at the bottom, you can't. It's not enforceable. But click wrap and browse wrap agreements are enforceable. Defamation. Defamation is the act of harming the reputation of another by making false statement to another person. The act of defamation may be a false written or oral statement. So if it is something that is written, let me break up. I'm going back to the book because it has a more detailed explanation, and you can also look at the page numbers because this might be important for the exam. So libel refers to a written defamatory statement, which means that if you write something about someone without putting in the facts, or by the way, so you know that even in the case of libel, there are certain criteria which makes the statement, um, legally, um, legally enforceable or implied laws that impact the libel statements. One is that the defendants published a defamatory statement. Of course, it has to be written, and there is a very high level of responsibility, especially for the writers in this situation, to only state facts. But not all facts are mm, construed as libel. Reason being that if it is a true state, even if it is a true statement of facts, there are certain privacies which is assumed to have a moral value for the society, and therefore it has made its way into the legal system uh, concerning things that are of private nature, like you cannot be putting cameras in somebody's bedrooms, and any act or anything that is recorded, or anything that is intrusion of privacy or considered private enough that even if it is factual statement of whatever occurred, but it may be covered under the privacy laws, uh, can also be cannot be printed, or it cannot be stated anywhere, or it cannot be shared by or with anyone. Um, the Other thing that is important in libel is that other people were exposed to the statement, meaning that if only you know the facts and you kept it to yourself and you wrote it somewhere or you recorded something somewhere and never exposed it to anybody or shared it with anybody else, it will not be falling under the laws of libel, and therefore you cannot cannot exercise any claims for libel. Okay. So two elements: the defendant published defamatory statement about the plaintiff, but like I said, defamatory statement uh, would also it doesn't mean that you can state all the facts and expose all the facts which are of private nature. Okay. In the case of slander, refers to spoken or oral defamatory statement. That means that if you spread the word around or if you share it with somebody as as a gossip, or where the tabloids create a story, um, even though if it is not written but it is even shared, or you talked about somebody with reference to something which is of private nature and it causes harm, actual harm, which means that there could be damages attached to it, this will be a slander. So the damages is the litmus test for slander. That means it has actually impacted somebody's image, somebody's reputation. So that's why we have companies these days that offer services like what they call reputation management. Um, and this goes for, both libel and slander has a higher level of impact if it is against a well-known personality or somebody that would actually, mm, would compromise their reputation for, or it is, harming any contractual obligations of somebody, just because it was a result of slander, and whoever the contractee is and the contractor, they might just not approve of it, or it may impact financially. So slander and libel has a higher threshold, has a lower threshold for common people and a higher threshold level for famous people who actually has a reputation to maintain. Damages in slander situation is sometimes difficult to pinpoint, but whoever is the plaintiff in this case has to prove that there were actual damages, which can be monetary damages or future damages, which may occur at later point in time as well. Okay. There is a spamming. Spamming, basically unsolicited commercial email. There could be phishing scams, advanced bank payments, pyramid schemes, and all of these. They fall under the spamming laws. Spamming is got a lot of gray areas. However, it is considered to be one of the causes of filing for or against anyone who is doing spamming in the shape of phishing stamp. And by the way, in spamming, there could be two liabilities. It could even be civil liabilities, which means that it was a nuisance factor, or it is, with the intent um, to cause some sort of a stressful situation for someone. Even that could be a cause for filing against somebody spamming or sending emails to you. But at the same time, the criminal liability can also be something that might be detected in the case of phishing, which means that these are fake emails that appear to have a legitimacy to it. But in actuality, these are actually scams and lead you to sites which would steal your information. So these are just giving example: fake health products and remedies, that is spamming also, and so on. So it just has so many dimensions to it, and it keeps evolving. Okay, so privacy, defamation, spamming, just get a general idea about it. If it comes in the exam, they would ask, especially in defamation, they would say, what is the difference between libel and slander? And they'll give you options, and they'll give you, a drop box to match against what situation or what is construed as libel versus slander. Public info, privilege info, private, and all of these are all explained in a general sense to give you an idea of how you would attempt your exam if you are given a choice between four of them in case of matching questions. Okay. Um, Now I really want to get to something here, which is what we call use case or case loss, or something that you may be able to answer if you were given the statements or some of the reading paras to go through, and then you will be asked to answer the questions. Now, yesterday, because James and Dorothy was not here, so I don't know how well you are equipped to answer the questions on copyrights. But Justin was here, and so he might be leading the answers for this. Okay. Um, hmm. Okay, just quickly, if I can, maybe see, this is the problem. I want to discuss these things, but I don't know. Okay, let's giving you a helping hand in this one. For example, if you read through this copyright case and look at the three paras that are explaining a situation, a scenario, and then there are these questions on the right hand side that you will be asked to answer. Okay. Okay, I'm going to leave it open, and I want you to read this quickly. These are three paras. It says Ronald is a first year law student at the university. One day he visits the coffee shop. Coffee shop. Okay. Be quiet for me. So, Dorothy, James, Justin, were you able to read through these three paras?
Yes.
Okay.
Yeah.
All right. So, here we are supposed to be answering a multiple choice questions. Unfortunately, it has like answers written as in numbers 1, 2, 3, 4, and the question number is also got a number to it. So let's just look at the first one. What is the copyright infringement issue in this scenario? So copyrights as and give it your best to based on your understanding of what copyrights entail. In general sense, you would have that grasp of the idea, so I'm sure you can at least try to attempt to answer the first one. um, Now here it is saying that what is the copyright infringement issue in this scenario? Photocopying a copyrighted protected book without the author's permission, professor claiming part of the profit. Second is irrelevant. The professor is not asking for part of the profit. Photocopying for the purpose of education. Now, if some material needs to be copied even for educational purposes, and it turns out that it's a whole book somebody is copying, I don't think that answer number three is appropriate, even in those books somewhere at the end, because they're all copyright protected. It would not give you a general permission, as in GNU or other public permission. So, um, copying a book and then claiming that it is for educational purposes is not legal. And then the answer, all of the above, since 2, 3, and 4 is not agreeable for it. I don't think that the only answer we're left with is the first one, photocopying a copyright protected book without the author's permission. So this is the copyright infringement. Sometimes it's a very simple answer. You just have to eliminate those that don't apply, and then whatever is left over should be the better answer. So in the first one, I would say first answer number 1 is most appropriate. In number 2, it says which right of the copyright owner is violated in this scenario. Now, in the copyrights law, there is very uh, there is a clarity of what is considered the rights of a copyright owner. So, I don't want to go back to it, but by answering this between me and Justin, we can keep answering it and you can probably make a note of it. So, Justin, in number 2, what do you think is the violation? The public display, the right.
I would say that it's number 2, the right to reproduce works.
Uh,
I think that's, yeah, no one has that right except for the publisher.
The right to reproduce the work. So number 2, I agree with that. And Justin is right answering this one. Let me see if it's possible. I can actually highlight it so you can later see it. Okay, let me break out this. So let's make this correct answer. And in this one, I'm going to highlight this as correct answer. Coming to, it's still visible, right? Okay. So in number 3, who is responsible for direct copyright infringement? Direct copyright infringement means that somebody has outright copied somebody's work and or reproduced it without asking the permission for copying it. In this case, photocopying. Okay. So that's called direct copyright infringement. So who is responsible? Is the author, original author of the book? Obviously not. I mean, he doesn't even know what you're doing with the book. The copy shop owner who is actually making the copies because the student took that book to the shop owner for making copies of it, or the university professor that asked the student to make copies. So who in this case is the direct infringer?
I would say, unfortunately, it's the copy shop owner.
Yes, I agree with you. Why? Because the university professor has said something, but he has not acted upon it. So, giving a command for doing something wrong may not make someone, an infringee or direct infringee of the copyrights. The student acted with the knowledge, knowing fully well that it may not be a good practice or it may be illegal, but still, whoever is acting upon something that is infringing the work is the copy shop owner, the copy shop owner. So he is the one who will be held directly responsible. So I would agree with Justin, and I would say number 2 is correct. In number 4, question number 4, who is responsible for contributory infringement? So contributory infringement means that, during the course of um, doing, some sort of, copyright infringement with whichever way you're going to do it, either you're going to copy something, download something, share something, but as long as there is a chain which says that the original producer of, first of all, the condition is the original owner does have absolute no knowledge that his or her work is being infringed upon, or they've made the copies. Second is where the parties along the line or along the chain of who actually acted upon or did the copying were totally oblivious or had no idea if they are doing something that is infringement of IP. So both parties may just lose connection and may not be um, held responsible as direct infringees, but indirect infringees. So that is contributory infringement. In this case, we've got four choices: the original author of the book, the copy shop owner, the university professor, or the student. So contributory, who had no idea if it is uh, correct or incorrect to copy it, or if the permission has been taken by the author. Who could that be? Between three people: the professor, the student, and the copy shop owner. This might be a tough one. Even for me, I don't know. As far
I,
as contributory,
yeah, I would say the professor, um,
hmm,
as being a part of it.
being part, okay. Hmm. I think the answer could be could be two and three. But if it is just one choice, the better answer could be the professor, uh, because the professor doesn't know if he's infringing copyrights. He thinks that it is an educational document and therefore it can be copied because students may not be able to afford it or for whatever reason. But the professor should have the knowledge, enough knowledge to know that, or sh- or should have an idea at least that he's directing the student to do something illegal. Um, so, but who was in the position of power to command or to direct something to get done? That could be another angle to look at, because the law would look at that aspect. So, university professor. So, let's take this as a better answer. Um, in your opinion, can this be qualified as fair use? Now, here they're talking about, usually the um, consumer rights agreements or the copyrights that are in public domain are restricted in so many different ways. One of them points to a fair use of that work, right? Fair use could be for educational purposes or not. It just depends on the type of contract. But if it is not in the public domain, it's a book, then it cannot be considered a part of the um, implied agreement or the uh, agreements like Creative Commons. And therefore, no would be the better answer because it's a book. Then we have another case law. We have to finish all of these, unfortunately, the time I have. And I also have to get done with the ethics. So it might take a little bit longer for us to finish today's session, because on Monday, I have requested one more class for you to attend, for all of you to attend. That's because I missed the one on last Friday. And what we needed to discuss for the last class is about the exams, how you can pass the CIRS exam, and then we can do some examples using the practice Q&A format, just to give you a sense of, confidence, or at least for you to know what you can expect in your exams when you looking at the formats and the process of how the exam takes place. So that's what we'll discuss on Monday. And that should be concluding everything for us for CIRS. So let's get this thing finished up. we've got about four more slides besides this one. So here the subject is link copying. Link copying comes in different, I don't know if I can explain everything, but let's just read through this first. And then then James and Dorothy, I'll explain with the answers that we give or figure out. I will explain about, the answers, and that way you can catch on. Larry is a professional freelance photographer for an award-winning wildlife nature magazine. Okay. So just give it some time and read through it. And if James and Dorothy, if you have a book open, um, because I was thinking of taking a 10 minutes, and if you'd like, you can look it up in the book. It's here. It's on page 450, 451. So if you'd like, you can check this. But in the meantime, I leave this open. Just read through this case study, and we'll take about 10, 15 minutes break right now. And I'll return back and we'll continue with getting the best answers we can for this. Okay. So I'll leave you with this open and see you in a little bit.
Okay.
Okay, I'm back. If you are available and if you're all back, just give me a nod if you can see my screen. I'd like to continue from here on.
Yep, saying that.
Okay, thank you. So, in the first question, they're asking what is the copyright infringement in a case in this situation? What do you say? Piracy means outright copying, right? Somebody's work. Caching, something that is debatable, is not actually part of the copyright infringement. Linking and framing could be a good contestant. Um, Framing is when you create a frame and you actually ask somebody, or you are or connecting that frame with the content that is actually running on somebody else's website, yet at the same time it is presented on whoever the infringer is on their website. Or that page has a frame which makes it look as if it is coming or internally generated from within the servers of that web page or the website. But linking is slightly different. Linking is when the link of that particular picture, in this case, is showing on Larry's website, whereas it is actually pointing to a site that is owned by Natural Heritage. And therefore, it is a case of linking and not framing. Um, that's why I think the best answer would be linking in this case. And they're explicitly mentioning it somewhere here that says that the link is pointing to those big pictures. All right. So linking is the answer for one. Then it says Larry is responsible for direct copyright infringement, contributory, vicarious liability, and none of the above. Um, Vicarious liability is when whoever is the infringee would not even know that they are doing any kind of infringement on copyrights, and whoever is actually acting on it also has no knowledge about it. So they are totally having no knowledge, and that is vicarious liability. But the case in which we are reading through these paras, I'd say, what do you think, Justin? Which could be the better answer between one and two? What do you think?
Direct copyright infringement.
Yes, I agree with you. It's direct infringement. So I will mark it. This was linking. And then in number three, what is the linking related copyright infringement in this situation? Um, Larry provides link in his website to copyright protected images. Larry refusing to remove the links from his images. Larry arguing um, that copyright images belong to him. This could be a better answer, in my opinion, unless you think number two is correct or number three is correct. It's providing links here. So number three, the answer is one. What can Larry do to seek permission from the publisher? Can go to the court, just talk to the publisher, can sign a linking agreement, all of the above.
Probably do all of them.
Yes, he can do all of them. Then we have the last question. What is the benefit of linking? Links allow quick and easy access to information. Links appear nice on the web page. Links allow secret access to other websites. The above. Probably number 4. So then let's read the piracy. Justin, your name is here.
Well,
Back at
either way, I wasn't involved.
You sure? Okay.
Absolutely.
Pressure from higher management side. Okay. So Justin says his rationale was we bought it and we can do what we want to do with it. That's kind of bold. Justin plan was okay. All right. Let's see what could be the answers. This is good.
I've actually dealt with this in real life. So
These errors. Hacking piracy. This is piracy, it's outright piracy because if you're given a license to use something with the limitation or with the contract that you obtain that product, um, you have to follow that limitation. And here it is outright piracy. Okay. It's not phishing, it's not linking, it's not hacking. And so the logical answer is piracy here. Accusing of piracy in this scenario refers to stealing computer software, purchasing one software package for multiple use, unauthorized access to another computer, stealing music and video games. Accusing of piracy in this scenario refers to, in this scenario, purchase one software for multiple users. What is the, if you don't agree with anything, you can just say that. What is the type of copyright infringement the company is liable for? Direct infringement, contributory infringement, vicarious liability. Justin is responsible for it. What is the risk of using pirated software according to the above situation? A lawsuit can be filed against such individuals or company compelled to pay a significant fine, potential private and public embarrassment. What do you think, Justin, in the fifth question? What do you say? The lawsuit can be filed against such individual or company.
I mean, I guess technically it would be all of the above, but um, I mean, you're in violation of your agreement with a company that provides the service. So I imagine they could bring a lawsuit against you if you
Yes,
don't comply.
correct.
So, but I guess technically it'd be all the above.
All of the above. And that's what I agree with as well. So, correct answers. I say that you are well prepared to tackle these questions. Plagiarism, plagiarism. So, Dorothy, would you care to read through this and see what could be the good answers? Just give it your best. And I don't expect, I mean, plagiarism is is a kind of a copyright infringement. But since you got the drift of, what is could be the better answers, you can try. So Todd is a senior at a university and only one semester to go prior to. So you can read through this. Submitted the answer to his course tutor. Ask him to prepare a draft. Hmm. So Todd has used the information without acknowledging the appropriate source. So, when you're writing academic papers or doing some assignments, you're given instructions and you are told or you are expected to follow a certain way of how you are going to do the citations. So if you copy somebody's work without acknowledgement or without their permission and you're not creating something new out of it, it is actually set in your paper exactly as you have placed it there without quoting it or referencing it to the original source. That is plagiarism, isn't it?
Yep, plagiarism.
Yeah. What are the unlawful acts he has committed in being liable for plagiarism? He had used both library resources and online material. He had used direct quotation. He had written the paper in a draft format. He delayed the submission of the draft paper.
Number two would be number two.
Number two. This is correct, believe. What are the best practices that Todd may have followed in correcting his mistake? He uses the only library material. He uses quotation and paragraphs.
Number two.
Agree?
All the above is for that one, I would argue. The number one's the most important one, but
Yeah, number one, I think um, you cannot replace few words if you are putting something within quotes or if that's the direct reference from something. So number one, I believe, is a better answer, in my opinion. What could have been the penalties for plagiarism in the above situation? Can be subject to fine, can be suspended, can fail the course, all of the above. So I'd say all of the above. Okay. We have now defamation. This is an interesting one. Thing was going smoothly until she started noticing. This is where the action starts. One of her top commenters, identified by pseudonym Eric, is somewhat sarcastic about it, although she didn't pay much attention to it in the beginning. So Martha need to establish the four elements of law that she can file a lawsuit or something that she can put as a claim for defamation in the court of law. Um, there has to be an actual damage. Others should know about it. It is a statement of facts. So these are the elements, but that's not what the question is about, but just letting you know before you can file anything for defamation. Now, based on the questions we have, we look for the best answer. What is the offense committed by the commenter identified by pseudonym Eric? Defamation, obviously. So these are not very difficult questions to tackle in the exam. They make sure that it's not um, something that's going to make it very, very difficult for students. So you could see that the questions are not as complicated. What is the type of defamation that Eric is responsible for?
Libel, because it's written.
Yes, exactly. According to the above scenario, what is the defamatory act committed by Eric? Posted offensive comments about Martha's skill as a blog writer. Posted offensive comments on his competency. Just had to refrain writing. Blog. What do you say? All of the above? Offensive comments. All of the above. That's what I could read here. What is the medium through which defamation happens? Now, this one, number 4, to read again, hardly starts at that. About her article, her skills having had enough of presence. And writing skills as a blog writer. It's the blog. Because blog, as long as it is in the common space and everybody else can read, uh, I mean, there is no word that says that it is a forum. It is a blog that's been criticized. Forum is a different platform altogether. A blog would have the comments under it, and therefore it is not technically a forum. Obviously, email and Facebook is not in question, so I would say blog is a better answer. Which of the following is and are elements required to establish a case of defamation? Publication. This is an important question. Question number 5. Which of the following are elements required? The publication to one other than the person defamed, false statement of facts. If the plaintiff is a public figure, he or she must also prove actual malice. Okay. Yes, the fourth element is the intent, which I forgot to mention, to file for the defamation. Intent is crucial. Uh, Things can happen by accident, or you may write your opinion without realizing you're causing a harm. Um, but if your intent is really to cause a harm, or if there is a malified involved, then that could be one more element that's added to filing for the defamation. So here, all of the above offenses happened. So number 4 is the answer to this. E-commerce. Okay. Rachel purchases 3 academic books. Let me run this one. Um, just to give you the information about how the contracts or electronic contracts are made online, or what is construed as contractual obligation between parties when you're using the somebody's website, or where the e-commerce transactions are taking place. There is this contract whose elements to make it effective will have to be um, part of the contract. Number one is that there has to be an agreement, that means offer and acceptance, and there has to be an exchange of benefit. It could be a barter also, but it has to be a value that can be translated into not just the benefit, but also having a monetary value to it. That means it should benefit both parties, whether compensation is with money or without money. So offer, acceptance, and consideration. Consideration is uh, barter, or some sort of benefit between parties, or it could be something that is exchange in monetary terms. So that is consideration. Okay. Now, let's, if you have read this part a little bit, maybe I can just wait a few minutes. I'll also read it quickly. She realizes that the book. So there are click-rec agreements involved when they're doing e-commerce transaction. Just so that you know, e-commerce is very complicated in terms of how the contracts are set. There are so many parties involved and there are so many moving parts in it. Um, Besides the consumer and the owner of the website, who is also the one that is selling products, um, through that process, would be under contractual obligations with parties such as the merchant services. Merchant services is responsible for allowing the use of Visa, MasterCards, and so many things. And this is called terminals or merchant terminals. So the banks that gives the merchant account or sets the merchant account are also using something called a gateway. Gateway could be a third party platform, which is a technical thing set for the actual transaction to go through the bank or connect through the bank. So, bank, which is the merchant account or the merchant bank, has a contract between the owner of the website, whereas the merchant bank also is under contract with the gateway company. And that transactional gateway, such as PayPal, or there could be others, Payoneer, and there are several others, those gateway companies also are under agreement not only with the bank but also with the vendor. So there is this circle of contractual obligations that are set separate from what relationship or what the consumer is supposed to be under legal obligations by using that website. So the contract between the vendor and the consumer is separate. And then between consumer and the consumer's credit card bank, they have another agreement, or it is something which at the time when the credit cards are issued, the consumer is given certain privileges or there are certain restrictions and obligations as well. So there are several contracts that are exactly and totally um, um, you know um, um, used for the transaction itself or the checkout cart or the cart, shopping cart. And then, besides that, the use of the website is another set of agreement, which now adds to the complexity because just by using those websites, the consumer is actually obligated to sign up what we call the browser app agreement, just the fact that they're using the website. So there is one set of agreement between the vendor and the consumer that way. And then there is click wrap agreements, which is really covering the vendor's interest. And therefore, it is an agreement which is um, to be accepted through the check mark first, we call click wrap, and only then they can proceed to the next level or the next stage of payment. So because of all these moving parts, sometimes it becomes very difficult to figure out exactly who to go after. And like I said, the moving part means that there could be a breach at any level or at any stage of the transaction. So that is the complexity of it. But we are not dealing with such deep complexity. We are just talking about the two agreements, browser app and click wrap agreements here. Um, Now, in the first question, it says, what is the type of e-commerce that Rachel is dealing with? Is it B2B, B2C, C2C, C2B. B2B means business to business, business to consumer, B2C, consumer to consumer, and consumer to business. So I think in this case, it is business to consumer or B2C. So that's the answer for the first. Second one, what is the type of e-contract that Rachel has entered into? Now, there is browse wrap agreement and click wrap. Okay. Email agreement. So what could it be? It means that if the transaction got done and if it is the shopping cart that was clicked on, and unless it was clicked on before, it wouldn't even come to this stage and none of the transactions would have happened. So more or less, it is click wrap agreement, which is more stringent and it has more of the clauses or legal clauses attached to it. This also means, by the way, click wrap agreements have different sort of it has different aspects of that contract that is covered besides privacy, privilege of use. Um, there is something that is to do with RMAs or return goods or refund policies. So there are policies as well that are covered in click wrap agreements, especially at the time of transaction, because it's crafted or it is designed to get the transaction through um, by initializing some payment process, but the consumer has to agree to it. And one of the things they will have to agree is the return policy. They're not going to talk about, how good of a service they're responsible for giving, or there is no service level agreements in that sense in click wrap agreements. So that's where the Rachel might want to read through and see what are the compliances that are not performed by the client or by the vendor or by the owner of the website. So click wrap agreement is the most dangerous one in this case. So I would just point to click wrap agreement. By the way, the browse wrap agreement is just for someone to be using the website. The most important part in terms and condition is, I believe, is the use or the privacy of information and how the consumer cannot use somebody's information because intellectual property is involved, and only that aspect is generally covered. But click wrap is what makes the transaction happen, or where the goods are to be shipped only when click wrap agreements are agreed to. Um, so, um, number three, let's see, what are the key elements of binding contract that the lawyer may have mentioned? Elements of a binding contract, just like in a regular situation where the contracts are made and signed, the virtual agreements have a similar weightage, or it has the similar response from the law to make it applicable or make it work in a virtual world. So all of the above, all three are part of the agreements, or it should be the basis of forming a legal agreement. So offer, acceptance, and consideration are three elements, and therefore all of the above makes it a binding contract. I'm going to. What are the things that Rachel can use as valid evidence to support her case? Emails she sent, recipient of payment, hotline contact, all of the above. I mean, you have to give as much evidence as you can to ensure that you are saying that you have done everything as a consumer to make that effort, and you were ignored or did not get any, it was not effective, and therefore your consumer rights were violated, and you got you had a product for which you have lost the money. So all of the above would be a better answer. Which of the following laws gives validity to electronic contracts? Computer fraud, communication decency, privacy, electronic signatures, Global Act. Uh, by the way, this question will not even come because you're not expected to know about the the naming of different laws, because in Canada it is named different, in USA it is different. So for that reason, this question number 5 is not valid. Okay. Um, Computer Fraud and Abuse Act. This is not a part of the US Act. It's therefore not a valid question. So I'm just going to leave it out. Okay. All right. Now, just so you know, in the contracts or electronic signatures or electronic contracts, you have to know that not all contracts can be signed electronically, or you could say the legal system both in USA and Canada, it would not allow a virtual contract or anything, even something that has your digital signatures in there, even that will not be valid. Some contracts, or the examples of those, are contracts for mortgages, where the physical, the witness have to be present, and there has to be physical signatures, property exchange or property purchase and sales, and rental agreements. All these are not considered valid, even if it is electronically signed. Electronic signatures can happen in different ways. You can have your signatures that are actually physically copied somewhere and kept as an image file. You can also have something encrypted with your name, which means that if the encryption has a key or a value um, that you put in there, which is unique to you, that could be electronic signatures also. But irrespective, the important part is which of the electronic agreements are valid and which are not. Okay. So that having said, if the question comes in the exam, is all electronic contracts valid? If you and we are not talking about click wrap agreements, and I'm not talking about browse wrap agreements. I'm talking about the contracts, that electronic contracts. Okay, so we are done with these examples, and I want to talk about the ethics of internet. What is ethics? And to give you an idea, when we are talking, see, ethics is a very controversial subject even in internet law, because ethics is something that does not have very specific guidelines. Ethics are dictated by rules or certain policies or certain good practices or general governance of matters to do with the profession. There are these specialized bodies that regulate those professions, and they are responsible for giving some guidelines on ethics. But ethics are just best practices or something that morally is accepted, um, uh, as um, as someone who would watch out for the public interest, and would be would be courteous, and have some sense of responsibility on using information, like preventing the from preventing the data from getting leaked out, or using somebody's information without their consent, certain privileges of having the information that can be used in a certain way. All those are moral obligations, and it is expected as a general norm that you will not only be the custodian of that information, but be protector as well. And the moral values that you grow up with. sometimes it has to do with the freedom of speech also, like how much of a consumer rights or your rights for using the internet you exercise within the confines of social values, like the social or socioeconomic values also. Some of the places where dictatorship is more prevalent, there is a lot of censorship, or there are certain issues that you cannot discuss because they're morally or they're considered morally a taboo to present or to put on the web as information, and so on and so forth. So this becomes subjective, and this becomes a situation where there cannot be a fixed guidelines. But in general, we look at certain things or certain situations where the morality, and we're talking about North American side of things, to look at these questions and get a sense of what could be morally subjected to some sort of a test for ethical concerns or ethical reasons of using that information. We have these questions to get a sense of what it could mean. So let's look at this slide. So the value of privacy, confidentiality, and anonymity. Okay. This is a question. So if we look at all these three things, we will be more on the side of uh, looking at, and this is going beyond just the legal aspect or the legal framework. Ethics, again, like I said, it's coming from your own values or your concerns or your way of how the society treats certain issues. So, privacy is very important in North America. Confidentiality is pretty much regulated. Anonymity can be subjective, or it could be the level of anonymity that one can exercise in using the internet as a medium to give views, opinions, or to write about. Then the question is, how about Googling clients? Should you now, if you are in HR business, you could see that there could be some guidelines that may allow or even prevent you from making a decision on a candidate based on their social media activities or looking at the social media accounts. So there could be certain informed consent that you have to get from the candidate, along with other consents to be able to do some due diligence and background checks. But just Googling the information and finding something about a candidate, is it morally significant, or um, is it considered ethical practice uh, to get into somebody's social media accounts, or they're finding out about their relationship, which has no direct relationship to their qualification or their background, job and professional information, but could be other factors. So how far you are supposed to uh, make your decision based on that. Then there is what is the role of AI in redefining ethics? Now, AI or artificial intelligence is mechanical in nature. It is programmed, and it has a factor of automation that might give you an insight into something that may not be as accurate, or it may not have certain elements that AI would not never be able to produce, like sentiment, values, relationship issues, and so on. Especially when it comes to privacy issues, how far AI would be impacting, or how much of the AI should you rely on and use in your information gathering? Or would it be able to replace things like automated surveys or surveys? And by the way, so these days there are surveys, they don't require the participation of your subject, especially human subjects I'm talking about. And it has a way of figuring out certain things by collecting information generally from Google. And then, it gives the possibilities, or it gives the likelihood of of making a decision about someone or something, just because the information is automatically gathered, and therefore it is doing pre-qualification, or it is pre-qualifying certain leads on its own. So that is one factor. Then you've got CCTV or multimedia. You've got CCTV that is in the public domain these days. How much of that would be considered, or you would take that information for which you don't have the consent from those that are actually being captured through CCTV to have an impact in any kind of decision making? Do you have to inform them, or do you have to take permission? And I'm talking about having a camera in the public domain. If something that you are in, something that is intrusion, considered intrusion of privacy, would you be able to collect that information and use it in any way? What is considered a private space is another question, especially, there is dash cams, whether the car where you're sitting inside, would that be considered your private space? And if anything is captured inside of a car by anyone who is outside of it or in the public domain, would that be legal for someone to use as information? So there is these ethical issues, but a lot is covered under the laws of privacy, defamation, and so on and so forth, but not to the extent where you may exercise your own personal judgment to see if you are causing a harm or potential harm to someone, or morally and ethically if it is correct or incorrect to take, let's say, account of anybody's household or activity inside their home or inside their private space, and use that, in your judgments or in your research. How about spreading news and sharing with social media or Twitter? Would you be acting as a responsible person to present or to upload or to use the internet for spreading news, or giving something for which you don't have a way of auditing or vetting or vouching for it or verifying it, and yet you have tweeted something, especially the tweets who get retweeted very quickly, and now the information spreads quickly, and so does the rumors and misinformation. So that is something that would be covered under ethics and moral values of realizing and expecting that the repercussions that it would cause. So that is a question of ethics, and line between ethics of contents and sensitivities. Like in certain part of the world, I mean, you won't be able to run certain photographs, or because of the censorship or because of religious reasons, they might be very sensitive, you know. So there could be a higher level of responsibility to use that content or to present it on the internet, because of the cultural differences, um, you know the uh, the religious reasons or whatever it may be. So that is what it is referring to. So sensitivities of that sort, sensitive issues also, where you're talking about abortion laws, especially North America, to have a very strong opinion about something as a writer. You have to be sensitive to those who are opposed to that thought or that idea, and so on. How about writing reviews, opinions, blogs, articles, and sharing links or hijacking someone's content? Obviously, outright, this is, some you can do it because internet is not stopping you, and there could be repercussions, or it might be ignored, but it is a personal responsibility. It is the quality that may be compromised. Your moral responsibility for for writing on subjects, with the non-biased approach. So that is that is covered under the ethics of how you are conducting yourself, responsible or not. How about forming a bias or influencing public opinion? So if you have strong opinions or opinions that are what we call, if you are campaigning for something that you believe in, you are, writing about an idea that is not validated, or it is something that is of where your personal views are involved, then you have to be careful about that. So bias is something that falls under the ethics of internet, and unless you've got a self check on it, especially strong opinions about something, right? uh, that you feel about, passionately feel about, you have to curtail that. You have to make it a balanced statement. Or even the information you're collecting, you may review it from a different perspective, whereas your colleague or somebody else may have different ideas or different ways of looking at it. So the information should be based on what the public might think if you are pro something or against something. So those strong ideas um, should not be influencing your information collection as well as your information use. What are the ethical limitations of freedom of speech and net neutrality? So these are very controversial and very personal subjects. Everybody has their own opinion, but to maintain the ethics or norms of responsibility of how you would treat certain subject matter is of utmost important to keep a self check and act responsibly when you're using that info or collecting that info. Works in both directions. Collection is most important. You need, like I said, there is a document called informed consent, especially in in when you are using surveys, especially, or you're doing focus group, virtual groups. Any information that you are collecting, you have to pose the right questions. It should not be too personal. It should be well balanced. There should not be leading questions or questions that can dupe someone, especially those vulnerable in the society, the elderlies, that you have to act responsibly to not take advantage of collecting information from them without their deep knowledge of why you're using it and how you are collecting it. The adult versus, the those under 18. So you have to, those are considered, or the children, those are considered to be more vulnerable subjects in your surveys. So there is a level of responsibility you have to apply. Online marketing, for the sake of, and there is a lot of cyber vandalism, we call it now. That's where the marketers have flooded the internet with misinformation. And those, without getting too deep into the different ways in which the marketing happens these days, um, there is a dearth of, or there is a huge volume of information that is what we call that. Some of it is called is it called funnel marketing, where it is given a very kosher blanket of using it as a strategy, whereas in fact it is a way of misdirecting, you could say, or directing people in a very subtle way to a direction where they initially did not intend to go, but you have dragged them or took them in that, or nudged them in that direction. So there could be so many different ways in marketing has lost its ethical value. of the true trends in which marketing process or the marketing um, job is supposed to be, you know, to be a kind of a skill, not that it is a kind of a way of vandalizing the web. So, how would somebody who's doing marketing or online web marketing, even SEO, to what extent they put themselves responsible or act responsibly uh, within the norms of ethics of internet? Okay. So, ethics at its simplest is a system of moral principles and how people make decisions and lead their lives. Lead their lives is not, I mean, we're not getting into the philosophical part, we just focused on the definition. So, the ones that are highlighted portions is what we will consider as the elements of what ethics is about. Moral principles, how people make decision, what is good for individuals and society. So this is again subjective, what you considered morally good or morally bad or morally acceptable by the society, whereas the society is acting on the other direction, or it is working as on the opposite poles of things, that is not considered ethical. You have to go with the flow and with the general principle of how the society dictates values and morals in its upbringing or in its making it into a mature nation, or growing in that environment is what teaches you what the moral values are. Benefits of studying, I think it avoids conflict and resolve. Obviously, if there is an issue that is, has got a majority in favor of, we are not actually establishing any conflict. Build respect and common ground of understanding. Okay, common ground of understanding obviously means that you will not have very strong opinions about something. You have to give it a medium path. Display one's professionalism. This is also important. Remember, some of the societies and associations and licensing bodies, they also are regulating the profession by adding the ethical aspects of how one should conduct themselves in a professional way. Those are some of the ways that they control or impose or implement or give out the ethical way of conducting themselves. If they don't comply with it, there could be trouble and they might just lose their license or may not. I mean, you can complain to those professional bodies. That is one of the reasons why it is important to have a profession regulated, and for someone to be part of the organizations. Okay, so that they are regulated. Adopt a more professional behavior in an online platform. Gain confidence of public. That's what it means. So that's just benefit of study. What is ethics? Now, these two could be the questions you would find in the exam. There's a very small layer of how the ethical questions are tackled in the exam. There could be maybe one or two questions. Mostly it is going to be around these questions. Okay. So they would say, what could be the moral aspect of it? What could be some of the ways that the morality or the ethical issues could arise when you're using it for collecting information? So these are the typical questions that might be interesting for you to basically work with. And it's a very short answer. So it could be maybe, uh, you know, like I said, it could be two questions with very short answers, nothing more detailed. Now, the next topic is the ethical dilemmas. Dilemma in this sense, what dilemma means is that there is no fixed, regulated, or book that is the absolute guideline for ethical practices. That's what the dilemma means here. But generally, there could be guidelines, there could be outlines of framework. of what could be the elements or what could be those attributes which would which you would want to look at carefully and ask questions yourself to be able to act according to these outlines. How to live a good life, no conflict, conflict free. Okay. Our rights and responsibilities as you grow up, you learn that through your school system, through your housing, your relatives, your parents, and so on. The language of right and wrong, this is what we learn automatically if we grew up in North America versus we grew up in Saudi Arabia versus we grew up in any third world countries, we would have different moral values because of socio-cultural as well as political aspects that actually influence all these moral values. Our concept of ethics have been derived from religious philosophy and cultures. They infuse debate. So this is philosophical, not as important. In the general sense, the dilemma, the word dilemma means that you have to ask questions based on these. What is internet research ethics? As far as the definition is concerned, we picked it up from Internet Research Ethics. It says analysis of ethical issues and applications of research ethics principle as they pertain to research conducted on the internet. So, what do we get when we are doing research? Responsibility for verifying the information, responsibility for obtaining informed consent, which is a legal document and it needs to be signed. What would be the responsibility for using that information, the integrity of that data to be maintained if it is something that requires privacy and so on. So those could be the ethical issues of collection of information, use of information, informed consent. These are the three elements. Now, key guiding principles of internet ethics. These are important, and let's go through them one by one. And this should pretty much conclude everything on ethics. So, what are the guiding principles? The greater the vulnerability of a subject or community, the greater the obligation to protect. So, as someone who is collecting information, I say collecting information. I am not using the word researcher. So anyone who is collecting could be the government department, it could be individuals, it could be businesses. Important aspect that you have to look at is the vulnerability or how informed the subject is about the information you're collecting on them or on that, and how you're collecting it for, and where are you going to use that information. But if you talk about vulnerability, it means those people who don't have a better sense or judgment of knowing where this information is going to be used, if it is underage or adults that you're dealing with, if there is sick or mentally not as competent people who could be a more vulnerable in the society. So there is this sliding scale of responsibility. The more vulnerability attached to the subject of your research, the more responsibility you have, and you have to act by taking caution and ensuring that communication is a lot better and it is understood between parties. If the parties are vulnerable, then you have to use third party or an outside resource that would actually become part of your collection of info as a witness or as someone who are responsible for those, especially in the case of children or under 18. Ethical decisions making is best approached through the application of practical judgment attentive to the specific context. It's talking about practical judgment. Practical means you have to be objective. It has to focus on the questions that are not very personable and personal questions, questions or anything that you have collected by directly interacting with someone. You have to make sure that they understand the objectivity of where it is going to be used. So your judgment would be in question. Due consideration of principle of ethics related to research on human subject. So what is the consideration of principle of ethics. Obviously, number one is the vulnerability. Second is informed consent. And the third is, of course, your responsibility to not intrude in their privacy or to use that information for deriving something which does not directly relate to or uh, to the focus of that research, uh, but it is collected out of your personal interest. So that needs to be separated, and it could actually create a problem for you. Uh, then we've got when making ethical decisions, researcher must balance the right of subject. The due right of subject may outweigh the benefit of research. Um, Certain information that is personal is, in fact, here they are talking about personal interviews. Okay. Um, you have to look at the the harm side, or the side where certain information can cause a problem both for you as an interviewer and for the interviewee. And you have to be cautious about asking leading questions, which could be a trap questions, or questions for which the subject of your interview is not ready to answer it, but because you have asked something that they couldn't understand or decipher, but yet they're able to say it to you, or you've collected that information, that obviously once it is given to you, you have it, but you don't own it. So for that reason, you have to be at least very clear about the questions. It should be well understood by the party, and it should not be very personal questions. That decision you have to make at the time of interviewing. um, and obviously there here the benefit, just because you have personal interest in gathering that information, but it does not apply to the objective of your research, that might outweigh the benefit, and therefore the subject versus outweighing the benefit might be questioned. Okay. Address ethical issues as they may arise and need to be addressed during all steps of the research process. That means you have to plan it, means that you have to sit and don't be random about collecting the information. Everything here is about collection of information. Using of it is the second liability or the second objective. But here, on the side of ethics of how we collect the information is what we are addressing. Um, all steps of research process. That means that, yes, actually what it's saying is that after you've collected the information, in fact, I interpreted it wrong. You may have to apply ethics in how you're using it, which is the second step. How you're analyzing it, would there be any bias involved? Those processes need to be part of um, how you are going to use all the um, morals and ethics of applying it, basically at every level. So how you collect it is ethical issues will arise. How you are using that information, ethical issues arise. How you are interpreting it, ethical issues arise. Who this information is being used by, ethics are involved. So this is different processes in your research. Then we've got ethical decision making is a deliberative process, and researchers should consult as many people and source as possible in the process. Ethics guidelines. So here they're saying that these could be different sort of a mix of ethics that apply for different reasons, different professions, and they're not you don't have one uh, absolute book or book of knowledge that will tell you what is ethically good or what is ethically not suitable. So you have to look for all those guidelines. The last thing is divisions in ethics of internet research. So when we talk about internet and ethics, there is the difference between the internet as research tool and as a venue. So the question is, if it is a research tool and it is a virtual venue, then what could be the issues that you have to tackle? So research tools, use of search engines, data aggregators, databases, catalogs, uh, how much of a dependency you will have on these. Would you go as far as to verify that information? Would that be or would it be sufficient just to use these as tools and rely on that information? Wouldn't it be your moral obligation to verify them and to see if they connect with or they are rightly collected and therefore it's reliable enough? But because you're using research tools like internet, it's very quick information. It's a matter of convenience. A lot of times you would just rely on it because you are in urgency of some sort. So that will play a role. A venue, would it be collected from chat rooms, forums, groups? These days, the problem is that the marketers, like I said, cyber vandalism, a lot of it is created by marketing companies. So they are basically, doing it as mass production factories of opinions, of groups, chats, and things, because they create that murmur, that create that dynamics in the forums just to, put in their comments or false ideas, or sometimes, some burning issues, something that is trendy or seasonal. They create that. So those venues are there, but how much of a value you will give to it is questionable. It depends on how you would apply your ethics in using that as a platform. It just depends on your depth of knowledge, obviously. Then we've got whether the internet search is engaged or non-intrusive. Engage means if it is directly connected with the subject, could be a human subject, or could be an environment, it could be multimedia, it could be a capture of some clips of, like in social experiments. So you want to make sure if the engagement is direct, so it is first-hand information, versus if it is in public space where you use your own bias, your own opinion, and therefore more of an obligation to you and for you to apply the ethical concerns and address them at the time when you're using it indirectly or collecting it through viewing it in public spaces. So these are the two different aspects of how the ethics on the internet research might impact or would require for you to um, work within the boundaries of what you think is ethically correct. Key ethical issues: understanding human subject matter. Okay, so informed consent, a document that you may want to Google and check. Informed consent means that you would, and the sample that you have collected for your research purposes, especially if it is human subjects. Okay, so understanding where they're coming from, whether they're vulnerable or not, how much of the information you're willing to give them in order for you to collect that info, how much of a clarity of an idea of where this information is being used, and so on. Whether the information is collected from public or private information process, of course, that is important. And informed consent is a document. When we say informed consent, there is actual physical document that, if you Google it, you can find it. There are so many samples. And like I said, it will have certain things in it that legally allows for both parties to have consent for and from each other based on disclosure of facts, and where the consent is explicitly given through signatures for collecting and using of info. Privacy, anonymity, confidentiality, and revealing identity. These are pretty much regulated. Anonymity in the sense of how the internet is presenting itself. Um, it obviously, you don't want to rely on some information that is collected from an anonymous source. A lot of times you'd seen in news, they say, from confidential source, because the source would give you the valid info unless it comes to disclosing it where it is legally required or where the credibility of that source is questionable, only then you may be able to disclose it. But otherwise, it is considered anonymous source. A lot of times, the surveys use pseudonames or different names without disclosing the identity, and that is anonymity also. And this is through a process of informed consent, which is subject to certain clauses. And so confidentiality is another one. How much is confidential, how much is not? It has to be a part of something that is in written format. So the confidentiality level has to be agreed upon. Privacy is highly regulated, and in especially in North America. Then you've got a question of consumer rights. What is net neutrality, freedom of speech, and so the whole kimono opens up. uh, Recruitment, there are certain principles and facts that you have to rely on in order for you to recruit the right sample. So, the recruitment process has to be carefully vetted. It has to be approved, not only between yourself and the client, but between yourself and whoever could be the recruiter. It could be your own company, or it could be somebody else that is collecting or recruiting the sample for research purposes. Okay, that's not like HR recruitment, by the way. That's different. Then copyrights, ebooks, contracts, disclaimers, and so on. So that is another subject of how you would drop off. Have a great evening and a weekend. All right, thank you. So anyway, I think we're done with this part, and this ends everything that you would find in your final exams. I believe I have covered everything. So there's a lot of information today, and what I'd say we could do on Monday, if you like. And by the way, James, I'll send you the link for the webinar tomorrow.
Thanks
In the
very much.
meantime, and sure, and in the meantime, I'll see you on Monday, and wish you a great weekend. Unless you have a question which I'm ready to answer, if anything at all. If
Yep.
not,
See you Monday. Have a good weekend.
see you Monday. Okay, have a great weekend also. All right,
Okay.
take care now. Bye
Thanks
bye.
in a bit. See you then. Bye
Thank
bye.
you. Bye bye.